instead of the neglect. She has to set a bond on the neglect. Not on neglect. No. Child abuse, it's hold for magistrate. She has to have a bond set.
Okay, cool.
Okay, hold on.
No? Oh.
Two prior,
You just walked in the door and it worked.
two prior DUIs and family court this afternoon, like to see if, what's going to be done about the supervision of the child.
Yeah.
Yeah. All right.
Is everybody ready? Ready? Ready?
I know I gave her something.
So the females. Yes, what jail would the females be in?
Well, this isn't even with the domestics. is it?
Okay. Yes. It's in the main jail, okay. Okay, thank you very much. Good morning, we're here for first appearance hearing Bernadette Torres.
Ms. Torres is here, President Main Judge. She's approaching. Good morning.
Good morning. Thank you.
With the Public Defender's Office, Judge.
Good morning.
Good morning.
Ms. Torres, you're charged with touch strike battery, dating violence, find probable cause, set bond in the amount of $1,500.
Judge?
Yes.
Speaking, Ms. Torres, my understanding,
Dude,
Judge,
it's about 8
is she's
years.
been residing in our community for about 8 years now. She's 37 years old. She works for a catering company. She helps set up and take down the event. She's been doing that for the past 4 years. She makes approximately $300 a week. She has no money in the bank, no property. Unfortunately, at this time, all the money that she had went towards her expenses. She has no money right now available to post her bond, and no one on the outside that's in a financial position to post her bond.
Okay.
My understanding, Judge, is she has a residence. Would you consider pretrial release on her behalf?
No, I'm going to find probable cause, set bond in the amount of $1,500 in order that she have no contact with the alleged victim in this case, Mr. Mumba.
Thank you, Judge.
Victoria Graham. Victoria Graham.
Graham is coming.
Ms. Graham, you're charged with touch strike battery. I find probable cause. Set bond in the amount of $1,500.
Judge.
No contact with the victim, Bertasha Torres.
Judge, and speaking with Ms. Graham, my understanding is this is her first offense ever. She's a registered voter. She currently works for UPS. She's been employed with that company for 5 years. Considering this is a misdemeanor offense, she's been residing in our community her whole life. Her ties, strong ties to the community. Her and the alleged victim do not reside together. She lives in Pompano Beach. She resides with her parents. Would you consider an ROR on Ms. Graham's behalf?
No, I'm going to set bond in the amount of $1,500. I find probable cause, order no contact.
Yes, Judge. Okay. Judge?
Yes?
I'm being advised by the deputies if we could call a person out of order.
Who is it?
Ms. Hastings, is that it, Deputy? Heising.
Hyacinth Henry on page 9.
Hyacinth Henry on page 9, Judge. Ms. Henry, come on up.
Hyacinth Henry. Good morning. You're here on a capias.
Good morning. Bonjour.
You're here for a capias on a misdemeanor charge. Bond is set in the amount of $500.
Okay. Thank you, Judge.
Tawana Sharice Jackson.
She's in Paul Ryan, Your Honor.
Tawana Sharice Jackson.
Yes, ma'am.
Good morning, Miss Jackson. You're charged with touch, strike, battery, domestic violence. I find probable cause in your case. Set bond in the amount of $1,500. Order no contact.
Your Honor, Miss Jackson has been living here in South Florida her entire life. She has an extensive family here. She has a 5-year-old child who is currently with her boyfriend. She's been living at the same location for 3 years. She does have a place to stay separate and apart from the alleged victim in the case. She can stay with her mother, and she's provided me with her mother's phone number to get a phone call to her to see about bonding her out. I don't know how much money is available. I don't know what funds the family has. From what Ms. Jackson tells me, it's not the best financial situation. I'd ask the court to consider a $1,000 bond.
State.
Your Honor, Ms. Jackson does have a criminal history, including a prior for violence. 2014, burglary of a dwelling and grand theft. 2011, she was convicted of strong-arm robbery, sentenced to 3-year state prison. 2008, burglary of a conveyance. She violated probation, sentenced to 3-year state prison.
Okay. Bond is set in the amount of $1,500. No contact with the alleged victim in this case. Servio. Medical reset. I should scratch it. DeAnthony Cobb.
Mr. Cobb is here, present, Judge of Maine.
Your Honor,
Main jail.
if we could please put that case on recall, the list of victims en route to the court.
Okay, we'll put that one on recall.
Have a seat, Mr. Cobb.
Yeah, which one was the medical reset? Yes. Sean Martin.
Mr. Martin, come on up, please.
Mr. Martin in the main. Good morning, Mr. Martin. You're charged with touch, strike, battery, dating violence. I find probable cause to set bond in the amount of $1,500. No contact with the alleged victim in this case, Angelica Naomi Callan.
Judge, Mr. Martin's asking me if you would consider reducing the bond $1,000. Right now, unfortunately, financially, he doesn't have any sort of resources. He is a welder. He's been only employed at that welding company for 1 month and a half.
State.
Unfortunately, at this time, he hasn't brought up.
Your Honor, State would ask the court to keep the bond you said in place. It appears Mr. Martin has limited ties. I see in his DHSMV that he only applied for a license and is a resident within the past year. He also has priors out of Massachusetts, 2013, abusing prevention order. It seems like that's akin to violating a restraining order. 2013, abusing a prevention order, intimidating a witness.
I'll leave the bond set at $1,500. I do find probable cause.
Yes, Judge.
Robert Cole.
Mr. Cole, coming up, please. He's coming up. He's all the way in back, Judge.
See who was against.
Mr. Cole, you're charged with touch, strike, battery, domestic violence. I do find probable cause in your case. Set bond in the amount of $1,500. No contact with the alleged victim in this case, Anthony Earl Cole.
Judge, and speaking Mr. Cole, the alleged victim is his brother.
Yes, I see that.
Mr. Cole will be residing separate and apart from his alleged brother. He'll be residing with a friend who lives in Davie. He's 51 years old. He's a roofer, lives paycheck to paycheck. He's been living here his whole entire life. He's asking if you would consider pretrial release.
State.
Your Honor, this gentleman has a previous battery, 1994, and as well as a battery on law enforcement officer. Aggravated battery, I'm sorry, Your Honor. From
Bond's,
87.
bond set in the amount of $1,500.
Yes, Judge.
Nariandis Dadlani.
Mr. Sadler? Yes, ma'am.
Ms. Dadlani, you're charged with touch, strike, battery, domestic violence. I do find probable cause in your case. I set bond in the amount of $1,500. No contact with the alleged victim in this case, Sherry Slattery.
Judge, Mr. Dedlani is asking if you would consider pretrial release. He does live separate and apart from the alleged victim. He'll be living with his friend who lives in Fort Lauderdale. He's been here his whole life, 34 years. My understanding, he has only one prior DUI. If the state can verify that, would you consider pretrial on his behalf?
State.
There's also a possession of cannabis, Your Honor, 2002, and the state asks that you keep the bond where it's set because of the level of violence.
Bond set in the amount of $1,500. Lawrence Thomas.
Mr. Thomas, come on up.
Morning, Mr. Thomas. You're charged with touch, strike, battery, domestic violence. I do find probable cause. Set bond in the amount of $500 on that. You're also charged with violation of probation. You're being held no bond on the violation of probation. You'll need to see your judge on that case.
Judge, our only request is would you sign an order allowing the public defender's office access in order to photograph Mr. Thomas's injuries?
Sure.
Thank you.
Pardon? No contact with the victim in that case. Thank you. Do you have that order, Mr. Reedy? Okay, thank you. Shane Raspberry?
I'm being advised medical loan, Judge.
Medical what?
Loan?
Okay. Robson Lucas de Silva Fernandez.
Judge, we're going to be requiring a Portuguese interpreter.
Okay.
I've already ordered one, Judge. They should be here shortly.
Okay, we should be, as soon as they get here, we'll let you know, okay?
Thank you.
David Pierre?
Mr. Pierre?
Sorry. Sorry? Okay. Mr. Pierre's on recall.
Mr. Pierre's on recall? Okay, have a seat. Your case on recall.
Vincent Panacea?
Mr. Panacea, come on up, please.
Good morning, Mr. Panacea. You're charged with touch, strike, battery, domestic violence. Also charged with abuse of the elderly or disabled adult without great bodily harm. I do find probable cause as to each of those. I set bond in the amount of $1,500 on each count. And you're also being held no bond on a violation of probation. You'll need to see your judge on that case.
Judge, our only request is would you sign a photo order as well?
Yes, I will.
Thank you, Judge.
Monshwar Hanuman.
Mr. Marshall Hanneman, come on up, please.
State could be heard before the court makes a determination.
Yes.
Your Honor, pursuant to the rules of criminal procedure, it states while Mr. Hanuman has to have his first appearance within 24 hours, a PC determination does not need to be made until within the first 48 hours. I'm going to be asking the court if the court would consider resetting this for tomorrow morning for probable cause determination.
I think the state's within their rights to ask for a 24-hour reset,
Okay.
but not another 24 hours after that.
Well, if that happens, we'll have to get into that because
I'll reset this till tomorrow morning at 8:30.
And Your Honor, and just noting for the record that this is not a perfection since the court has not made a determination yet.
Right, no finding being made today. Today is the 30th, right?
Yes, Judge.
Tomorrow's the 31st. We received that. Jaipur Howard?
Mr. Howard's here, Judge, I mean.
Mr. Howard, you're here on a bond surrender, also on a out-of-state hold felony. I do find probable cause. Yes.
This is a corrective from confinement center.
Pardon me? Oh, okay. Mr. Howard, you're here on a capias, a no bond hold on a capias. You're also on an out-of-state hold, no bond for forgery, theft, and obstruction of justice. I do find probable cause.
Judge, Mr. Howard is inquiring as far as what was the date of the offense that you missed the court date on?
I don't see that information. I do see that there's a capias for grand theft auto with Judge Siegel.
Thank you, Judge.
We'll just put, for now, we'll put our paperwork together.
Suze Jaboham.
She's in Paul Ryan, Your Honor.
All right, thank you. Suze Jaboham. Good morning.
Good morning.
You're here on 1, 2, 3, 4 separate capiases on one case number. Capias bond in the amount of $150 on count 1, $150 on count 2, $150 on count 3, $150 on count 4. I do find probable cause.
Mr. Obaham, I know we had spoken earlier. Do you have any thoughts about trying to resolve these cases if the judge was so inclined to do so, or do you intend to bond yourself out?
How can I resolve the case? Because I was waiting on, how can I resolve it? First of all, I think I explained to you what's going on.
Okay, that's fine.
Mr. Reedy, I'm not inclined to, in light of her driving record, I'm not inclined to resolve that today.
Okay, very well. All right, good luck, Mr. Obaham.
Okay, thank you.
Stacy Grover.
Yes,
No
Your Honor.
prayer, Your Honor. No prayer.
Stacy Grover.
Yes, ma'am, Your Honor.
You're here this morning driving on a suspended driver's license. You have a $100 bond, failure to wear a safety belt, and a capias on a misdemeanor charge. Bond is set in the amount of $1,000 on that misdemeanor capias. I do find probable cause.
Okay, yes, Your Honor. So my bond is $1,000?
1,100.
Thank you, Your Honor.
Kenesha Rainey. All right.
Yes.
Good morning, Ms. Rainey. You're charged with touch strike battery. Your bond is set in the amount of $1,000. I do find probable cause.
Your Honor, state would just request no victim contact.
No victim contact. The victim in this case, alleged victim is Vertasha Trika Torres. You understand that, Ms. Rainey?
Yes.
Okay, no contact. Lisa Burton.
Hi, Donna.
Good morning, Ms. Burton. You're charged with possession of cocaine and possession of drug paraphernalia. Your bond is set in the amount of $1,000. I do find probable cause.
Your Honor, Ms. Burton's been living here in Florida for 15 years. She does have she has her boyfriend is here. She's not working right now as she collects Social Security. She indicated to me that if her bond was set in somewhere in the area of $500, she would be able to self-bond out.
State.
I think the $1,000 bond's reasonable, Your Honor. In 2010 and 2009, she went through drug court for possession of cocaine. In 2008, she had a possession of cocaine, violated probation, was sentenced to 2 years state prison. 08, possession of prescription meds without a prescription. 06, possession of cocaine, 27 and a half months state prison. 05, possession of cocaine with intent, VOP, 27 and a half months. There's
Bond
more.
is set in the amount of $1,000. Can I call any of these, good morning. Can I call any of these lawyers out of turn, or? Mr. Redikoff?
I believe it's on page 11. Let me just see. It is on page 11. Katie Boyer, Judge.
Ms. Boyer, to your presence, President Maine, monitor, your presence, Mr. Radcliffe.
Morning, Mr. Radikoff.
Good morning, Judge. Bruce Radikoff.
Katie
on behalf of
Boyer?
Katie Boyer.
That's in the main jail. Ms. Boyer,
Yes,
your attorney, Mr. Radikoff, is present here this morning.
yes, ma'am.
You're charged with abuse of a child without great bodily harm, driving on a suspended driver's license, and failure to stop or remain in an accident involving not serious injury. Mr. Radikoff,
Judge, I've read the probable cause affidavit, and all I can say is obviously the facts, I won't call it egregious, but looking at the probable cause affidavit, Ms. Boyer did receive a head injury, as you can see, in the jail. She was treated for that head injury at Broward General. Prior to this, there have been no incidences with her child. Tried to get some family in here this morning. She's a lifelong resident. She's been working at Flanagan's for the last 2 years as a waitress. Her mom owns a home in Boynton. And again, her mom and she are not very well off as far as bond is concerned. She's not really capable of posting a large bond. I know that the court has to be concerned about the child. The child is with the mom right now. Obviously, her bigger problem is with DCF right now.
child is with who?
The mom right now.
Her mother?
Yeah, it's Goldenberg.
State, wish to be heard?
Your Honor, yes, the state's going to be seeking a $5,000 bond. Obviously, the allegations are concerning, and what's also concerning, Your Honor, Ms. Boyer has 2 prior DUIs. 2014 DUI with a breath alcohol above a .15. She was also driving on a suspended license at the time on that case. Additionally, 2012 she had a DUI where she violated probation. And just noting for the record, Your Honor, that the officer checked off the alcohol influence box on the probable cause affidavit.
Judge, she's not charged with DUI here. It is a suspended license. If the court's concerned about her driving, clearly, as much as I don't want to suggest this, a monitor would certainly monitor whether she's driving as well as where she is and what she's doing. I think the bigger concern right now would be, again, protection of the community, and a monitor might help, and protection of the child. The child is protected right now. So I'd ask the court there's been no failure to appears in the past that I'm aware of. So for purposes of bond, I'd ask the court to consider setting a standard bond of $1,000.
I'm going to set bond in the amount of $2,500, as well as a pretrial release with a GPS monitor.
Your Honor, what about count 3?
Count 3, ROR.
Thank you, Judge.
And there is a cost of $5 per day for clients who wear a GPS monitor.
I'm going to ask the court if you... Go ahead. Let you
Is
finish.
the court going to waive that fee, or must she pay the $5 per day?
She must pay it until further order of the court. So.
Regarding contact with the child?
That's going to be up to somebody
Say
other
no
than
contact until DCF.
state.
Your Honor, I was going to be asking for no contact till further order of the court. The concern being is, I don't know if a report, this won't end up for a shelter hearing unless a report's been made to DCF. I don't know if a report's been made to DCF. I don't know if Child Protective Services was notified, Your Honor.
Nor do I from the reading of the probable cause affidavit, but I do find probable cause. I set bond on count 1, $2,500, count 3, ROR, a pretrial GPS monitor. I'll leave the status of the visitation with the child up to somebody other than me this morning.
Katie, you understand that you have to come up with 10% of that, right?
So I won't write anything on the pretrial
Okay.
order regarding...
Contact me when you get out.
Thank you.
Yeah, thank you, Bruce.
Okay. Thank you, Judge. Good to see you.
Count 2 is 100, Your Honor?
Pardon me?
Count 2 remains at 100?
Yes, count 2 remains at 100.
Thank you, Your Honor.
Any other attorney need to approach? Anybody here on another matter? Okay. Jennifer, Mr. Odom?
Taylor, he's on page 13 of your docket. Robert Taylor, page 13 of the docket.
Where is he?
Oh, I'm sorry, Judge. He's at North Broward Borough.
North Broward. Robert Taylor. Mr. Taylor available?
North Broward, Your Honor.
Is this Mr. Taylor?
Yes, sir. Judge, I'm standing in on behalf of John McLawrence. I've done a template order. I'm asking an appointment on Mr. Taylor's case. It's a municipal ordinance violation.
Has he filled out an affidavit?
They traditionally do not, Judge. The court will decide at the magistrate hearing whether or not they will. Well, I should stand corrected. Traditionally, we will request appointment at the magistrate hearing, and then the courts will appoint at that point.
Okay, I'll appoint Mr. McLawrence to represent, is it you or Mr. McLawrence?
Mr. McLawrence.
Mr. McLawrence
The order should be over there.
to represent Mr. Taylor. Mr. Taylor, you're here this morning on two separate capiases, two different warrants. Actually, sorry, it's one case. It's a municipal ordinance. You have a $500 bond on the capias or the warrant. It was issued by, looks like, can't see who it is. State, you have a position on this? He's charged with disorderly conduct and trespass.
Judge, because it's a municipal ordinance, it's
Oh, yeah,
actually
it's a
the city
municipal ordinance
prosecutor of
case.
Fort Lauderdale would be the government agent in this matter. So traditionally, they're not here. If it's something that the court would be inclined to resolve, I would ask the court to do so. The court has full authority and jurisdiction to do so outside the presence of the city prosecutor, and we would be asking.
Mr. Taylor, want to resolve this case today?
Yes, ma'am.
Raise your right hand. You swear or affirm to tell me the truth?
Swear to God.
You can put your hand down, sir. Mr. Taylor, you're charged with one count of disorderly conduct, one count of trespass. You understand that?
Yes,
You're charged by way of municipal ordinance violation, punishable by up to 60 days in the county jail. You understand?
yes, ma'am.
You have an attorney here present with you this morning who indicates to me that you'd like to resolve this case this morning by way of a plea.
Yes, ma'am.
Is that what you'd like to do?
Yes, ma'am.
How many days has he been in jail?
On just this recent arrest, Judge, it would be 1 day. I don't have the accurate calculation prior to that.
Mr. Taylor, if you want to resolve this today, it's going to be 3 days in the Broward County Jail. You understand? How would you like to plead, guilty or no contest?
No contest.
You understand that your attorney here is representing you. You satisfied with that?
Yes, sir. Yes, ma'am.
Okay. I'll accept your plea of no contest. On count 1 and count 2, I'll adjudicate him guilty. Sentence him to 3 days in the Broward County Jail.
So, ma'am.
Credit for the 1 day that you've served.
Thank you, Judge.
So actually, ma'am, can I ask a question?
You have an attorney here, sir.
Well, depends.
So that'll be like Friday or something?
3 days in the Broward County Jail. I'm not in charge of when they let you out.
It would be up to. It's 3 days, Mr. Taylor. You get credit for 1 day, but what the court is saying is technically, BSO will release you in no later than 3 days. Okay.
Okay. Credit for time served. Yes.
And Judge, I believe BSO asked, and I would ask the court to run a concurrent, not consecutive.
It's concurrent.
Thank you, Judge.
Thank you. You have anything else?
That's all I have in here, Judge.
Okay.
Good morning, Judge.
Good morning.
We just have one case for this morning's docket, Oneida Sumner.
Yeah, we're going to have to do that in a little while. So
Okay.
if you guys want to come back, it's okay. Let me get through this docket, okay?
How long should we come back in?
Probably an hour or so.
Okay.
Okay?
Thank you.
See you then. Jennifer Balch.
North Broward, Your Honor.
Ms. Balch? What, pardon? Okay, thank you. Ms. Balch, you're here this morning on a warrant, possession of fentanyl. There's no bond that was issued by see who the judge is on the case, but I do find probable cause that there's a warrant for your arrest on a felony, capious, no bond. You'll need to see your judge on that case.
How do I do that?
You have a court date on June 1st at 9 a.m.
That's tomorrow. Okay.
Amanda Tyler.
Thank you. Yes, ma'am.
Where's Amanda Tyler? In the main jail?
Paul Ryan.
Amanda Tyler, you're here this morning on violation of probation on 2 separate cases. You're being held no bond on each of those. I do find probable cause. You need to see Judge Robinson.
Yes, Your Honor.
Jasmine Jones.
Good morning.
Good morning, Ms. Jones. You're here this morning on a violation of probation. I do find probable cause there's a warrant for your arrest on a violation of probation. It's a no bond. You need to see Judge Bailey.
On, what day?
Not sure when that'll be. Do you have any idea, Mr. Reedy?
It looks like June 1st at 9 a.m.
Okay. June 1st at 9 a.m. Atlantis Wentgart Steenson. Good morning. Charged with possession of cannabis, 20 grams or less, possession of THC, bond set in the amount of $1,000, and an improper right turn. I do find probable cause. Your bond is $1,000, ma'am.
Okay, I'm going to call your mom, okay?
Thank you.
All right.
Dominique Gray.
Yes, ma'am.
Good morning, Ms. Gray. You're here on 2 separate cases. One is a capious on a felony case. One is a capious or warrant on a misdemeanor case. There's no bond on the felony case, and there's a $5,000 bond set on the misdemeanor. You'll need to see your judge on those cases. I do find probable cause. Do you have any idea, Mr. Reedy?
I'm not 100% sure. I see a court date of June 12th at 8:30. But I'm not sure which case that's on, the misdemeanor or the felony.
Okay. You'll need to see your judge on that one. Patrick Moylan.
Mr. Moylan's coming up, Judge?
Is he in the main jail?
Yes, that means Judge.
Mr. Moylan, you're charged with touch, strike, battery, domestic violence. I do find probable cause. Wish to be heard regarding bond.
Yes, Judge. And seeing Mr. Moylan, he's been residing in our community his whole life. He's 23 years old. At this point, he's looking for employment. He was previously employed with a construction company making about $12.50. However, at this time, he was let go, and now he's looking. He has no money in bank, no property. He'll be living separately from the alleged victim. My understanding is this is his first arrest. Considering this is his first arrest, Judge, we'd be asking you to consider a $1,000 bond on Mr. Moylan's behalf and asking you to sign a photo order.
State.
Based on the level of violence, I was just going to be requesting a $1,500 bond and no victim contact.
It looked like Mr. Moylan was on the receiving end of a little violence himself here, Judge. I've already drafted the photo order, so it might be a mutual combat type of situation.
I do find probable cause. I will set bond in the amount of $1,000. I will order Mr. Moylan not to have any contact with his father, who's the alleged victim in this case, Patrick Moylan, and to reside somewhere other than where he was residing, if that's where he was living. I will sign an order for photographs.
Yes, Judge.
George Sontag.
Mr. Sontag, this is your present judge at Maine. This is a municipal ordinance case, so our office doesn't represent him.
Mr. Sontag, you're charged with a capious or warrant for carrying an open container. You understand that?
Yes, ma'am.
Would you like to resolve this case today?
Yes.
Okay, we need you to raise your right hand for me, sir. You swear or affirm to tell me the truth?
Yes, I do.
You can put your hand down. As I said, Mr. Sontag, you're charged with carrying an open container. There was a warrant issued for your failing to appear on that case. And if you'd like to resolve it today, my sentence would be 3 days in the Broward County Jail, credit for time served. You understand?
Yes.
Would you like to resolve this case today?
That means I can go?
I've sentenced you to 3 days in the Broward County Jail, credit for whatever time you have.
All right.
Is that what you want to do?
Excuse me?
Is that what you would like to do this morning?
Yes.
Okay, so you understand you don't have to do that. You have a right to have a trial on this case. Your bond currently is set in the amount of $100. If you'd like to bond out and see the judge and go to trial on this case, would you like to do that?
Yes, I would. Please.
You'd like to see the judge and bond out rather than resolve it today? Okay, I do find
How long will that take?
Mr. Sontag, I do find probable cause in your case. Bond is set in the amount of $100, okay? You can bond out for $100.
Judge, also one other thing as a friend of the court, this is a municipal ordinance. If he's indigent, he would be entitled to account.
Right, but I'll appoint Mr. McLawrence on the case. Actually, it's a Hallandale case. So I don't know that Mr. McLawrence handles those.
He handles, I believe, just City of Fort Lauderdale and
Right.
county cases. So there's a dilemma, but he is entitled to account.
I understand. He's at large is the problem. Mr. Sontag, do you understand what I'm saying to you?
I can pay the fine and go.
No, there's no fine. Your bond is set at $100 if you wanted to bond out. If you would like to resolve or end this case today, you can do so by way of a plea, but that requires you to enter a plea of either guilty or no contest. Would you like to do that?
Yeah, no contest.
Okay, you understand you do not have to do that.
Yes.
And if you would like to not resolve this case today, you could see a different judge on a different day. You understand that? Would you like to enter a plea of no contest today?
Yes.
Okay. You understand that if you do so, I'm going to adjudicate you guilty and impose 3 days in the Broward County Jail. You understand that?
And I get time served?
You get time served for whatever time you have in.
I've been there for 3 days. So
Okay.
this is my
How would you like to plead, sir? Guilty or no contest?
no contest.
Okay, I'll accept your plea of no contest. I'm going to adjudicate you guilty and impose 3 days in the Broward County Jail and give you credit for time served, okay?
Yes, ma'am.
Richard McEwing.
Mr. McEwing is here present, Judge Maine. He's all the way in back. He's approaching. Come on up, Mr. McEwing. Mr. McEwing is here present, Judge, and speaking Mr. McEwing, he's asking if Your Honor will consider resolving his case today for time served.
Mr. McEwing, you understand what you're charged with? You're charged with obstructing on a highway.
Yes.
Would you like to resolve your case today?
Yes.
Please raise your right hand. You swear or affirm to tell me the truth?
Yes.
You can put your hand down. Mr. McEwen, you're charged with obstructing traffic on a public street and impeding approaching motor vehicles. You understand that?
Yes.
If you plead guilty or no contest today, I'm going to adjudicate you guilty, impose 3 days in the Broward County Jail. You understand?
Yes.
How would you like to plead, guilty or no contest?
No contest.
I'll accept your plea of no contest. I'll adjudicate you guilty, impose 3 days in the Broward County Jail, and give you credit for time served.
Okay, thank you.
Brian Robbins.
Mr. Robin, come on up. Mr. Robbins also inquiring if Your Honor will consider resolving his case today for adjudication time served.
Mr. Robbins, would you like to resolve your case today?
Yes, Your Honor.
I need you to raise your right hand, sir. You swear or affirm to tell me the truth?
Yes, sir. Yes, ma'am.
You can put your hand down. State your full legal name for me.
Ryan Keith Robbins.
Mr. Robbins, you're charged with obstructing of a highway on a public street. You understand that?
Yes, Your Honor.
If you plead guilty or no contest today, I'm going to adjudicate you guilty, impose 3 days in the Broward County Jail. Is that what you want to do?
Yes, Your Honor.
How would you like to plead, guilty or no contest?
No contest.
Okay, I'll adjudicate you guilty of obstructing the highway. I'll sentence you to 3 days in the Broward County Jail. Give you credit for time served. Okay?
Okay.
Linzel Beasley.
Mr. Beasley is here present, Judge at Maine.
Mr. Beasley, you're charged with criminal mischief, $200 or under $1,000. Bond is set in the amount of $100, and you're also here on a capias on a misdemeanor charge. Bond on that case is set in the amount of $500. I do find probable cause. Your total bond is $600, sir.
Judge, I understand in reference to count one, there may be some issues as far as potentially resolving it. So we'd be respectfully asking you if you would consider an R on count one, so therefore Mr. Beasley can gather whatever resources or friends to potentially post his bond on count two.
Well, the victim's not here on count one, which appears to be his mother, so I'm not going to resolve that today. Bond set in the amount of $100 on that case.
Just ask for
No contact?
yes.
The state's asking for no contact on count one. Do you have a position on that?
Judge, I believe it's within the court's discretion to impose that or not.
Yes, it's clearly within my discretion. I just wondered if you had a position.
With no that's where he lives.
I understand, but
If you impose a no contact order, then you'll have to. I don't know where he's going to be residing at. I know he said he has friends. Hopefully, then he could live with a friend. That's why we would be initially requesting an ROR on count one.
I'm not going to ROR him. His bond is set in the amount of $100. I'm going to order that he have no contact with Tracy Nelson Davis until further order of the court. If he gets out and he wants to have contact, he can go before the judge that's handling the case.
Yes, sir.
Aria Stephen Loper.
Mr. Loper is here present, Judge?
Mr. Loper is charged with loitering and prowling. State, do you have a position on this case?
One moment, Your Honor. I do, Your Honor. I would ask the court, as one, not to resolve it, and considering this involves someone's residence. I'd advise the court, one, I'm showing Mr. Loper has a warrant out of the state of Louisiana from February 24th of this year for a failure to appear in court on a harassing communication. I'm also getting hits out of Minnesota for criminal history. One moment, Your Honor. Serious charges, but they were dropped out of Louisiana, in addition to the cases on the warrant on.
You have any priors on this?
Yes, Your Honor. See, one moment. It's a little difficult to read through some of these. I'm showing he's got, okay. There was an arrest earlier this month for Grand Theft Auto out of Martin County that was dropped. His prior arrest out of Minnesota and Louisiana, Your Honor, unfortunately, the NCIC doesn't show dispositions at this time.
Okay. I'm going to raise the bond in this case to $500.
And Your Honor, we just asked that there be an order of no return to the property.
No return to the property where this incident occurred at 6314 Northwest 78th Street in Parkland, and no contact whatsoever, indirect or direct, with Babar Shahzad.
Judge, the only thing I'd ask is, and speaking to Mr. Loper, he's working in construction. He makes about $10 an hour. Considering this is a second-degree misdemeanor, would you reconsider lowering it from $500 to $100?
The bond set in the amount of $500. I do find probable cause. Eric Perez.
Mr. Perez is here, Judge, approaching.
Good morning, Mr. Perez. You're here on a writ of arrest. Looks like a child support matter. Bond is set in the amount of $367, which is the purge amount on that writ. There's also a capias for a criminal traffic case. Bond is set in the amount of $250 on that case. I do find probable cause.
Judge, Mr. Perez is inquiring if Your Honor would consider resolving count 2. It is a 2009 case, so therefore, whatever money he has, he can use towards the purge amount on the writ of arrest for child support.
I'm not going to resolve the case. His license is suspended as a result of a number of 893 violations, so I'm not inclined to resolve that today. Bond is set in the amount of $250 on that count.
Yes, Judge.
Whose mother?
Last case, Judge.
Is that Mr. Perez's mother?
Do we need Mr. Perez back, Judge?
Is that Mr. Perez's mother? Is going to hear what? That she's here? Okay. We're done with that case, though. Charles Allen Hill.
Mr. Hill is here present, Judge. He declined to serve as public defender.
Okay, Mr. Hill, you're here charged with operating without a valid driver's license. Bond is set in the amount of $25 on that case. You're also here on a capias or a warrant on a criminal traffic case. Bond was previously set by a different judge in the amount of $500. So your bond is $525. I do find probable cause.
Okay.
Thank you.
Thank you.
Mikhail Gerard Graham.
Mr. Graham's here present, Judge, at Maine.
Good morning, Mr. Graham. You're charged with you're here on a capias or a warrant on a misdemeanor case. Bond is set in the amount of $100 on that case. You're also here on a capias or a criminal traffic case where bond is set in the amount of $500. I do find probable cause. Your total bond is $600, Mr. Graham.
Yes, Judge, thank you. You'll be seeing Judge June 2nd at 9 a.m., all right? Good luck.
Schneider Valken.
Mr. Valson is here present, Judge, at Maine. Judge, Mr. Valson is inquiring if the court would consider resolving the case for an adjudication time served this morning.
No, I'm not inclined to resolve it this morning. Mr. Valken, you're charged with resisting an officer without violence. Your bond is set in the amount of $100. I do find probable cause on your case. $100 bond.
Yes, sir.
Christian Felix. Mr. Felix, you're here this morning charged with petty theft. Bond is set in the amount of $100 on the petty theft. Also, one count of drug paraphernalia. There's no bond required on that count. You're also on a violation of probation on a felony case. You're being held no bond on that case. You'll need to see your felony judge on that case. I do find probable cause.
Judge, my understanding probation stems out of West Palm Beach. Would you consider an ROR on count 1 so therefore West Palm Beach can come and pick up Mr. Felix?
I will. I'll ROR him on count 1.
Thank you, Judge.
Oh, Eddie. He's apparently already posted the cash bond.
Oh, okay. Thank you.
All right. Hector Delgado.
Mr. Delgado, come on up, please. Who's here present?
Mr. Delgado's here on a warrant from 2010 from Judge Seidman, charged with violating probation on a criminal traffic charge. The warrant alleges failing to submit monthly reports on the charge of operating without a valid. Would you like to resolve this today?
Let me talk to him. I believe he
There's a no bond hold from Judge Seidman from 2010.
He does want to resolve his case, but I believe his first language is Spanish, not English. He understands English to an extent, so to be cautious, we'd be asking for a Spanish interpreter to go through the plea colloquy.
Okay. We'll put it on recall.
Tomasen, por favor.
Could we call for a Spanish interpreter? Please. Christopher Eddie.
Eddie. Is your president manager?
Is it Edie or Eddie?
Easy.
Edie?
Yes, ma'am.
Good morning, Mr. Edie. You're here charged with 1 count of grand theft auto. You're also charged with resisting an officer without violence and count 3, resisting an officer without violence. Bond is set in the amount of $1,000 on count 1. No bond required on counts 2 and 3. I do find probable cause. Your bond is $1,000.
Yes, sir.
Isaias David Padilla.
Mr. Padilla, come on up. Judge, he advised me that he has private counsel, Mr. Larry Schweitzer.
Okay, Mr. Padilla, you're here this morning for a first appearance on an aggravated battery with a deadly weapon, domestic violence. You're being held on a no bond hold from Judge Cohen, so you'll need to see Judge Cohen and let your attorney know that you need to see him. Okay? I do find probable cause. Yes.
Sorry, this is actually from a not in custody information.
Oh, is it?
Bond has to be set at his first appearance.
Oh, okay. Sorry about that. I'm seeing a no bond here.
It's on the booking. It has hold for magistrates. This is on Bailey. It might be different on the file.
Oh, it's a capious Judge Cohen case, which.
Oh, I'm sorry.
Pardon?
Oh, it's the same situation. Yeah, it's never been brought. The case has never been brought before Judge Cohen. It was just the.
Was it not in custody capious?
The clerk's office issued
a no bond capious. Okay. State, you have a position on bond?
Yes, Your Honor. State's requesting $10,000 bond, and this is Nicole Hamukos with the state for the record, Your Honor.
Any priors?
One moment, please, Your Honor.
Mr. Padilla, I don't want you to say anything because you have a private attorney. I'm just determining your bond amount, okay?
Sure.
No priors, Your Honor.
Okay, I'm going to set bond in the amount of $5,000 on this case. I do find probable cause.
Your Honor, the victims...
No contact with the alleged victim in this case.
Kristen Jones.
What is it?
Kristen Jones.
Kristen?
Jones.
Kristen Jones. No contact, direct or indirect. You understand that?
Yes.
Okay. Medel Martinez. Mr. Martinez, you're here charged with resisting an officer without violence. Bond is set in the amount of $100 on that. There's a capious or warrant on a felony case. You're being held no bond on that. You need to see Judge Porth.
When is that gonna be? Right now, I don't have the.
I do find probable cause. James Andrew Bailey.
Mr. Bailey, come on up.
Yeah, it's the same thing. Can we see three? Can we see this first? So what are you thinking? What was the weapon?
Mr. Bailey, you're here this morning charged with aggravated assault with a deadly weapon without intent to kill. You're also charged with touch strike battery. Bond on that count has been set at $1,000. And count 3, aggravated assault with a deadly weapon without intent to kill. I do find probable cause. State, you wish to be heard on the bond?
Yes, Your Honor, the state's requesting $15,000 each count, and there is a prior, Your Honor, from 2015, an aggravated assault deadly weapon, as well as 2013, resisting without violence, and 99, Your Honor, grand theft, which was a violation of probation, as well as 89, resisting without violence, battery and a law enforcement officer. The law enforcement officer was declined, though, Your Honor.
Pardon?
The battery on law enforcement officer was declined.
Okay. Defense?
Judge Stephen Bailey, he's been residing in South Florida for 49 years, his whole entire life. At this time, he has no stable employment. He works off and on whenever he gets a call for an AC company. He makes approximately $13 whenever he actually has employment. Financially, there's no money in bank, no property. Unfortunately, at this time, he is homeless. Therefore, he has no sort of financial resource and no one to post his bond. I'd ask you to take that into consideration in determining a reasonable bond on counts 1 and 3, and ask you to sign a photo order so we could photograph Mr. Bailey's injuries as a result of this incident.
I will sign a photo order. I do find probable cause. On count 1, I'm going to set bond in the amount of $5,000. Count 2, count 2 is $1,000. Count 3, I'm going to set bond in the amount of $5,000. I'm going to order, as a condition of that bond, you have no contact with Tammy Lynn Sewell or James Ronald McCall. You understand that, Mr. Bailey?
Yes, ma'am.
Okay. Thomas Powers.
He's approaching Judge Amin.
Good morning. Mr. Powers, you're here on a violation of probation warrant on 2 separate cases. You're being held no bond on those warrants. You need to see Judge Singal. I do find probable cause.
June 1st, 8:45 a.m. Good luck, sir. Okay, thank you.
Michael Crouch.
Mr. Crouch.
Mr. Crouch, charged with possession of cannabis. Count 1. Bond is set in the amount of $100. You're also here on a violation of probation case and a violation of probation on a misdemeanor case. 1 felony, 1 misdemeanor. Being held no bond on each of those violations of probation. You'll need to see your judge on each of those. I do find probable cause.
Thank you. What do I?
Jason Narcissi.
Mr. Narcissi, come on up, please.
Mr. Narcissi, you're charged with burglary of an unoccupied structure unarmed. You're also charged with grand theft auto, resisting an officer without violence, and a probation violation where you're being held no bond on that, and leaving the scene of a crash involving damage to property. State wish to be heard on the bond?
Yes, Your Honor, state's requesting $5,000 bond on count 1.
Okay. Defense?
Judge, we'd be requesting $1,000 bond on count 1, considering on count 4 he has a no bond hold on a BOP.
I'll set on count 1, bond's going to be $2,500. On count 2, bond is $1,000. Count 3, bond is $100. There's a no bond hold on the violation of community control. And leaving a scene of an accident, there's a $100 bond. I do find probable cause as to each count.
Yes, sir.
Cheyenne White.
Mr. White, come on up, please.
It's the co-defendant of the previous case. Mr. White, you're charged with burglary, an occupied structure, unarmed, grand theft auto, resisting an officer without violence, failure to remove obstructed vehicle from property damage, and operating without a valid driver's license. State wish to be heard on this?
Yes, Your Honor. State's requesting $3,500, count one.
Defense.
Judge, esteemed Mr. White, my understanding is he has one prior misdemeanor offense. He's been residing here his whole life for the past 20 years. At this time, he does landscaping. His own business. He gets like $25 per yard that he cuts. He lives in Hollywood with his mother. He's been residing in the same location in the apartment for 2 years. Judge, we'd be asking you to consider a $1,000 bond considering his strong ties to the community.
On count one is a $2,500 bond. Count two is a $1,000 bond. Count three is $100. And count five is $25. I do find probable cause as to all counts.
Judge, we'd be asking you to sign a photo order as well.
I would be happy to. Adolfo Aguilar Garcia.
Judge, Mr. Aguilar Garcia is going to require a Spanish interpreter.
Okay.
Yeah, we should have one on their way, Judge.
Toma asiento, por favor.
So we'll put it on recall.
While on the subject of interpreters, I've been advised that we will not have a Portuguese interpreter available until 1:30.
Okay, so that was on, that was on,
Was it David Pierre?
yes, that was, I think it was Robson Lucas de Silva Fernandez.
Yes.
Was that
It
it?
was a reset from yesterday.
Okay. So we're gonna reset it till 1:30.
Okay, he's here. Okay, I'll let him know, Judge.
Ronald Castaneda. Mr. Castaneda, you're charged with driving on a suspended license, third or subsequent offense. Bond is set in the amount of $750. I do find probable cause on your case. Stanley Benjamin.
Mr. Benjamin, come on up, please.
Mr. Benjamin, you're charged with burglary of an unoccupied structure, unarmed. You're also charged with grand theft, and criminal mischief. Looks like those are no bond holds from Judge Merrigan.
Judge, I believe they're non-custody cases.
Are they? Is that what they are? Pardon? State, you wish to be heard?
Yes, Your Honor. State requesting a $10,000 bond, count one. Your Honor, he has 2014 burglary with damage to structure, 3 years, damage over $1,000. I'm sorry, Your Honor, which was a VOP violation, sentence probation 3 years. 2014 grand theft, also a VOP probation, 3.5 years probation. 2016 grand theft, also a violation of probation, 180 days prison. 2000. Okay, then that's it, Your Honor.
Judge, esteemed Mr. Benjamin, he's been residing in South Florida his whole life. He's 20 years old. He just got a job. He's started at 7-Eleven this week. He's making $8.25 an hour. Financially, has no money in bank, no property. He lives in Hollywood. He's been living in the same apartment for about 4 months now. His monthly rent is about $900 a month. We'd be asking you to set a $2,500 bond on count one and $1,000 bond on the subsequent counts, Judge.
The probable cause affidavit only establishes that there are, in fact, no bond K pieces on that. I don't have a probable cause as to the facts of the case.
Your Honor, we can, if you just give me 1 moment, I can provide you with that.
Okay. Okay.
fine, you should do that. They use fingerprints.
Thank you. So the priors you read off to me, are those juvenile priors?
They were, looks like they were direct files.
Pardon?
They were all in the circuit court, looks like they were direct files.
Okay. And this is a juvenile probable cause affidavit?
It's a direct file also.
Okay, but he's 20.
Yeah, it was a direct file back from, one moment, I just want to see when it was actually filed. This was filed May 16th, I guess based upon, one moment, as you can see.
So it was a DNA match.
Yeah, we just got that, it looks like April of this year.
Okay.
And the determination was made then, I guess, while I'm not that knowledgeable about the law with regards to this, he was eligible for direct file.
So the offense date is February 5th, 2014.
That is correct, Judge.
So the priors that you read to me, they're after 2014 or?
Two of them are in 2014. I don't have offense dates, though, Your Honor.
Yeah, we don't know the specific dates, but two were 2000, had 2014 case numbers. The most recent grand theft had a 2016 case number.
And the most recent arrest since 2014? Or
There's one from
conviction?
2016, Judge, and then there was a case from 2017 that was declined.
Okay. Okay, on count one, I do find probable cause as to all counts. On count one, bond is set in the amount of $1,000. Count two, bond is set in the amount of $1,000. Count three, bond is set in the amount of $1,000. And count four, bond is set in the amount of $1,000. I do find probable cause as to all counts. No return to the location where this incident occurred. That incident location is (931) Northeast 4th Avenue in the city of Fort Lauderdale. You understand that?
Yes, ma'am.
Okay.
Good luck, sir.
Norbert Faden.
Mr. Friday?
Mr. Faden, you're here on a violation of probation. Your case is, you're being held no bond on that violation of probation warrant. I do find probable cause you need to see Judge Rothschild.
Good luck.
Handel Newell.
I've been advised to bond it, Judge.
I do find probable cause. I still need to do that. Right. Christopher, looks like Sessa.
Mr. Sessa, he bonded as well, Judge.
Okay, I do find probable cause. Robert Topel.
Good morning, Your Honor. Mr. Topel, Department of Service Public Defender, Judge.
Mr. Topel, you're here this morning. You're charged with aggravated battery on a person 65 years of age or older. Do not say anything about the facts of your case. Everything's being recorded. I do find probable cause state you wish to be heard.
Yes, ma'am.
Not you, sir.
If we could just have one moment, Your Honor.
Pardon?
We could just have one moment, Your Honor.
Okay.
Your Honor, the state's requesting a $5,000 bond and no victim contact.
Has there been any contact with the victim from the state?
No, not as of yet, Your Honor. Also, oh wait, no, is there a number?
Any priors?
We had a prior list for battery.
There's a prior arrest for a battery that was dropped in 2008.
Same victim or not?
One moment, Your Honor.
Yes.
It's hard to be certain. 'Cause
Okay.
In my system, it's a family member. It's listed as William Topol. I see that's the victim's middle name. I don't know if I can't be certain.
Okay. Mr. Topol, I do find probable cause on this case. I'm going to set bond in the amount of $5,000. I'm going to order that you have no contact with the alleged victim, in this case, Albert William Topol. You understand?
Your Honor, would you consider allowing contact? I'm a disabled veteran and my uncle is a disabled veteran. I provide care for him and take him to the VA.
I'm going to order no Mr. Topol, I'm going to order no contact at this time. If you want to see the judge who's handling your case, you can address that with that judge at a different time. But for purposes of today, bond is set in the amount of $5,000 and you're ordered to have no contact. Indirect or directly, okay?
Yes, ma'am.
That's enough to make sure either that DCF was either contact or that we will.
Okay. Okay. Good morning. If you could raise your right hand, please. You swear to translate from English to Spanish and Spanish to English to the best of your ability.
I will, Your Honor. Luz Angela Lopez, LOPEZ, certified Spanish interpreter for the courthouse.
How about Hector Delgado?
Señor Héctor Delgado.
Mr. Delgado? Senor Delgado? Buenos días.
Good morning.
Mr. Delgado, there's an interpreter here. Can you see her?
Señor Delgado, hay una intérprete aquí. ¿La ve usted? Yes.
Okay, you're here today charged with a violation of probation.
Está usted aquí detenido por haber quebrantado una libertad vigilada o probatoria.
And the violation of probation is for a case that looks like it's a 2009 case.
La quebrantación es por un caso que, según parece, es de 2009.
Please raise your right hand, sir.
Levante su mano derecha, señor.
You swear or affirm to tell me the truth?
¿Usted jura o afirma decirme la verdad? Yes.
You can put your hand down.
Baje la mano, señor.
Could you state your full legal name, sir?
Diga su nombre legal completo. Héctor Núñez Delgado.
Okay, Mr. Delgado, as I said, you're here for a violation of probation. A warrant was signed by Judge Seidman back in 2010.
Señor Delgado, como le dije anteriormente, usted está detenido por haber quebrantado una libertad vigilada que había sido, esta orden de captura fue firmada por el señor juez Seidman en el 2010.
And that warrant signed by him has no bond on it.
Y esa orden de captura que había firmado ese juez dice que no se puede imponer una fianza.
Would you like to try to resolve this case today?
¿Quisiera usted resolver ese caso hoy?
Sí.
Yes.
You understand that you don't have to do that?
¿Comprende, señor, que usted no tiene que hacer eso?
Sí.
Yes.
You could see the judge who's handling this case now.
¿Usted comprende que usted podría ir ante el juez que está llevando a cabo este caso?
And you're entitled to have a hearing on this case if you'd like.
Y usted tiene derecho a que le den una audiencia referente a este caso. ¿Comprende usted?
Sí.
Yes.
But if you'd like to resolve it today, adjudicate you guilty and give you credit for time served.
Pero si usted quiere resolver su caso hoy, la oferta que le doy es de declararlo culpable y darle como sentencia el tiempo que ha cumplido en la cárcel.
Sí.
Yes.
Okay, so you understand that what you have to do if you'd like me to resolve it today is that you have to admit that you violated your probation back in 2010. Is that right?
Usted comprende que para yo aceptar su declaración y que usted pueda resolver su caso hoy, usted tiene que reconocer o admitir que usted quebrantó esa libertad vigilada del 2010.
Sí.
Yes.
Okay, based on your admission that you violated probation and the warrant here before me, I'm going to adjudicate you guilty of operating without a valid driver's license. I'm going to sentence you to time served in the Broward County Jail.
Señor, basado en el affidavit que tengo aquí y el reconocimiento que usted ha dado de haber quebrantado esa libertad vigilada en el 2010, lo declaro culpable de la acusación de estar conduciendo sin una licencia válida. I am so sorry, Your Honor. The interpreter just blanked on the last part, Your Honor.
Time served in the Broward
Time
County
served,
Jail.
yes, Your Honor. I just wrote the notes, but sí, señor. Y le dan como sentencia el tiempo que ha cumplido en la cárcel en el condado de Broward.
Sí.
Good luck,
Yes.
sir.
Buena suerte, señor. Thank you, Your Honor. I'm sorry.
Yes, revoke the probation and
Señor,
terminate it.
señor, un momento. Señor Delgado.
Thank you.
La señora de los servicios especiales de la corte le dice a la señora juez que entonces le revocan esa probatoria y se la termina. Dice la señora juez que sí. ¿De acuerdo?
Gracias.
Okay.
Thank you. Your Honor, should the interpreter make an announcement?
I think we have one more. Adolfo Aguilar Garcia.
Señor Aguilar.
Good morning, sir.
Buenos días, señor. Good morning.
You're here today charged with one count of possession of cocaine.
Señor, está usted detenido hoy por la acusación de posesión de cocaína.
You're also charged with violation of probation on a misdemeanor case from Judge Seidman. The Judge Seidman signed a warrant on this case on June 16, 2010.
Señor, también usted está detenido por haber quebrantado una libertad vigilada y para esta quebrantación hay una orden de captura que fue firmada por el señor juez Simon junio 16 de 2010.
You're also charged with operating without a valid driver's license,
También lo acusan de estar operando un vehículo sin una licencia válida.
possession of an open container,
También de tener en su tenencia una lata o envase abierto.
leaving the scene of an accident involving damage to property,
De alejarse del lugar de los hechos de un accidente en el cual había causado daño a la propiedad ajena.
and false ID given to a law enforcement
Y
officer.
también de haber dado una identificación falsa a un agente de la policía.
Bond is set in the amount of $1,000 on possession of cocaine,
Para la acusación de posesión de cocaína le impongo una fianza de $1,000
and on the violation of probation warrant, you're being held no bond.
y por la orden de captura por esa quebrantación de la libertad vigilada no le pueden imponer fianza para que salga en libertad.
You'll need to see the judge on that case.
Usted tendrá que ver el juez en ese caso, ir ante el juez de
I
ese
do
caso.
find probable cause
Encuentro motivo fundado
as to all counts.
para detenerlo en cuanto a todas las acusaciones.
Good luck, sir.
Buena suerte, señor.
You want to make
Thank
it?
you.
Want to make it
Yes, Your Honor. Absolutely. Buenos días. ¿Alguien más necesita que se le interprete su caso en español?
Señor Sosa, ¿no? There's one more gentleman, Judge.
Okay.
He speaks English, Spanish, but he's more comfortable with Spanish, Judge.
Buenos días, señor.
I don't have this paperwork. Oh,
He's
wait.
on page
Good morning.
25, second to the last person on the whole entire document.
His name is?
Alvarez Segundo Sosa.
Están diciendo el nombre suyo, señor, y dónde se encuentra en esa lista de casos.
Okay, so this is the one that was reset from yesterday, is that right?
A esta persona, a usted le habían puesto la fecha para hoy, de ayer para hoy.
Yes, Your Honor, this was up for perfection.
Este caso había pedido el fiscal que le dieran tiempo para perfeccionar la acusación.
Okay.
I was advised that Judge Zeller found that because his first DUI,
Yo averigüé que la señora juez Zeller, debido a que el caso es de la primera vez que lo acusaron de DUI, estar conduciendo bajo los efectos,
was not also within 10 years of the DUI before Your Honor.
tampoco no estaba dentro de los 10 años del caso que está aquí ante la señora juez,
That he could not be charged with DUI third offense within 10 years.
que no lo podían acusar a usted de estar conduciendo bajo los efectos de DUI dentro de un periodo de 10 años,
Okay.
como tercera vez.
I am looking at the probable cause affidavit as well as the
Estoy mirando la
statute
affidavit
that the
de
state
motivo
provided
fundado
me
y también los estatutos que me ha proporcionado la Fiscalía
with regard to the
en
driving
cuanto a
under
lo
the
que concierne de
third
estar conduciendo
offense.
bajo los efectos y es la
within 10
tercera
years.
delito dentro de un periodo de 10 años, perdón.
I do note that Judge Zeller does
También
have
sé
some
que la
notes here
juez
with regard to the
Zeller
bond,
tiene notas
which
aquí en cuanto a la
indicated
fianza.
yesterday On
y
count one,
me indicó que en la primera acusación $1,000 de multa,
count two,
perdón, $1,000 de
$1,000.
fianza, para la segunda acusación
Count three,
$1,000
$1,000.
de fianza, para la tercera acusación
Count
$1,000
four,
de fianza,
$1,000.
para la cuarta acusación $1,000 de fianza,
Count five, ROR.
para la quinta acusación dejarlo en libertad bajo su propia
And it
responsabilidad.
looks like she found probable cause as to all
Y
counts
también
except for
encontró
count
un
four.
motivo fundado para todas las acusaciones excepto para la cuarta
She
acusación.
also indicated that
También indicó ella a la señora juez que le habían ordenado que usted lo dejaran en libertad bajo los servicios especiales de la corte,
along with a TAD monitor.
además de esto con un monitor que se le ponía en su tobillo.
As to count four, I do find probable
En
cause.
cuanto, I'm so sorry, Your Honor, please
Count
repeat
four.
your- En cuanto a la cuarta acusación, la señora juez encuentra motivo fundado para detenerlo.
I do find probable cause.
Encuentra motivo fundado.
And so if he wants to
Entonces, si
postpone
usted
it,
quiere pagar una fianza para salir en libertad,
total of
el
$4,000.
total sería $4,000.
Pretrial release
También saldría en libertad bajo esos servicios especiales de la corte
and a TAD monitor.
y le pondrían un monitor TAD.
Thank you.
Your Honor,
Gracias.
just to note for the record, Your Honor, I also provided Mr. Sosa Alvarez's driver's license record to the court.
También para el acta, dice el señor fiscal, proporcioné para el acta y para la señora juez el expediente de conducción del señor
And
Sosa.
I've reviewed that. Thank
Y
you.
yo lo he revisado, dice la señora juez. Gracias. Thank you. That was it.
Next one.
Thank you. Have a good day, everybody.
Thank you. DeAnthony Cobb, that was on recall.
Okay, toma asiento.
Come on up, ma'am.
Anthony Cobb.
Good morning.
Good morning.
Mr. DeAnthony Cobb, you're here this morning charged with touch or strike battery domestic violence. I do find probable cause on that case. State, do you wish to be heard as to bond?
Your Honor, I just would like to provide the court with Mr. Cobb's criminal history before the court
Okay.
sets a bond. In 2013, Mr. Cobb was arrested for domestic violence battery. One moment, I just want to see who the alleged victim was. That was against a different alleged victim, and the charge was dropped. 2007, robbery by sudden snatching. He violated probation. 2006, battery and resisting without violence. That was against a different alleged woman, and he was convicted of the battery count, both counts. Disorderly conduct, 06, reckless driving, 05. End of record, Your Honor.
And would you say your name, please, ma'am?
LaShayla Derrico.
And what would you like to tell me this morning?
It was just the argument. We was in public, though.
Pardon?
We was arguing, but it wasn't nothing serious. We was in public. He did not hit me. It was just verbally arguing, back to back.
Well, this probable cause affidavit says that you told the police that he slapped you when
I did not tell the police nothing like that.
and you had your 2-week-old son with you.
I did not tell the police nothing like that.
Okay. Defense?
As far as probable cause, I'll leave that to my colleague as far as the facts goes, but as far as being Mr. Cobb, he informed me he's been residing in South Florida 30 years. 1 year short of his whole entire life. He's 31 years old. He's currently working. He works for LA Fitness. He's been working for the same company for now 5 years, making about $15 an hour. Financially has about $300 in the bank. Judge, he does have members of his family that live in our community in Broward County. We'd be asking you on Mr. Cobb's behalf to take into consideration what the alleged victim said and ask you at this time to consider a $500 bond on Mr. Cobb's behalf.
And I would add, Judge, that I think based on what LaShala?
Yes, I did not tell the police nothing like
What,
that.
what she said here today, I think, casts probable cause in this case into some serious doubt. This is a very brief probable cause affidavit, Your Honor. There are not a lot of details in here at all. It does indicate they do have a 2-week-old son together, and the extent of the contact appears to be a slap. I think Ms. LaShala told the police right away she did not desire prosecution. And the way the officer even seems to phrase it is that the victim did not desire prosecution, but due to the domestic nature of the incident, the defendant was placed under arrest. So I'd be asking the court to consider, the guy sounds like he has a pretty good job. I know he's got a few things in his past. I'd ask the court to consider an ROR or possibly pretrial release. They have a young child together. I'm getting the feeling that, ma'am, are you afraid of him?
No.
Do you think if he comes back
We
into
always
your house that
we
there's going to be a
always
problem?
We always argue.
But is it arguing or is it
It's
fighting?
just physical.
Physical or verbal?
I mean verbal.
Not
yes.
physical.
Not physical.
Verbal.
I'm sorry.
Okay, all right.
Okay, well, I will take in, ma'am, are you're telling this court that would you raise your right hand, please? You swear or affirm to tell the truth?
Yes.
And you state your full name again for the record?
La Shayla Derrico.
You can put your hand down. You're telling this court that you're not afraid of Mr. Cobb?
I'm not.
And that you are not in fear for either you or your child?
No, I'm not.
Do you live together?
Yes.
Okay, I'm going to set bond in the amount of $1,000. And I'm not going to order that he not have contact in light of the victim's testimony.
Thank you.
Thank you, Judge.
Thank you, Judge. Good luck, sir.
No, I don't. Oh, because I didn't order no contact. Okay. David Pierre. This was on recall too. David Pierre.
What page are Mr. Pierre on, Judge?
He's on page 6.
Thank you.
Is somebody here on this case? Okay. Good morning, ma'am. Could you please raise your right hand? Swear or affirm to tell me the truth? You can put your hand down. Would you state your full legal name?
Sasheen Natalia Eastwood.
And what's your relationship to Mr. Pierre?
My boyfriend.
Pardon?
My boyfriend.
Okay. And what would you like to tell me here this morning?
What options do I have? What can I say?
Well, what brought you here this morning? Anybody force you or threaten you to come here?
No.
Did you come here on your own free will?
Yes.
Okay. Have you talked to anybody about the case?
No.
Nobody?
Well,
Okay. Are you afraid of Mr. Pierre?
no, I'm not.
Pardon?
No, I'm not.
And do you live with him?
Yes.
How long have you been living with him?
It's been almost like a year.
Okay.
It stops, like making me look crazy.
State?
Well, Your Honor, this certainly does have more detail. It's based on the level of violence. I'm concerned about the allegation of him preventing her from calling 911. Your Honor, I'm going to be asking for a $2,500 bond on each count. I understand that even though the victim has told Your Honor, she's not in fear, I am still going to be asking the court to place a no contact order on Mr. Pierre. The reason being, whether, one moment, Your Honor, whether Ms. Eastwood is in fear or not, that really isn't going to make a difference if Mr. Pierre should choose to commit another battery against her. Additionally, he's shown, based on these allegations, that he has no problem if she's trying to call 911 for her protection to prevent her. Also noting that there was an independent witness to at least some of this, what happened.
Do you have any priors?
One moment, Judge.
Judge, also, speaking of Mr. Pierre, the state lows, my understanding is he's been residing in South Florida since 2009. He works at City Furniture. He's been working there for about a year, making approximately.
Pardon? He has no prior record? Thank you.
He has strong ties to community. He's graduated from Coral Springs High School, class of 2010. He went to attend Broward College here in our community. As pretrial just confirmed, this is his first exposure to the criminal justice system. He has members of his family that live in our community in Broward. His mother is specifically in Tamarack. Judge, you've heard from the victim herself. She's not here. I'd ask you to take that into consideration. I'd ask you to take his strong ties into consideration in determining a reasonable bond on Mr. Pierre's behalf.
Okay, I do find probable cause as to Mr. Pierre's charges, touch, strike, battery, domestic violence. On count 1, I'm going to set bond in the amount of $2,500. On count 2, I'll ROR him. I am going to order that he not have contact, at least now, right now, with the alleged victim in this case, Miss Eastwood, until further order of the court. You understand that, Mr. Pierre?
Yes.
No contact, direct or indirect, until you see another judge other than me. You understand that?
Yes, no.
Okay. Bond is in, do find probable cause, bonds total $2,500.
Thank you.
Thank you for coming, ma'am. Looks like I have one other reset from yesterday. Carlton Sidney Barnes.
Mr. Barnes, come on up.
Your Honor, this is a perfection on the criminal mischief count. I imagine it doesn't make any reference to the amount of the damage. Your Honor, I'm not. I would just ask the court to make a finding of probable cause for misdemeanor criminal mischief, and however you want to proceed with the
Defense.
That's fine, Judge. I know Mr. Barnes currently, I think, has a total bond of $3,725 on his other charges. I'd ask you to consider RORing him on this misdemeanor.
Okay, on count 2, I will find probable cause as to a misdemeanor criminal mischief. And on that count, I'll release him on his own recognizance.
Thank you, Judge.
Thank you, Judge.
Does that look like it's all? Anybody else have any matters to be heard? Thank you.